Bared on the 29th of July 2009, the latest set of individuals to be inducted into the Order of National Artists, or the ONA, caused such controversy as to hit the headlines. At the heart of the scandal were perceived irregularities in the selection process. In an unprecedented exercise of presidential prerogative, then President Gloria Macapagal Arroyo refused to confirm the proclamation of composer and musicologist Ramon Santos. Santos has been one of the choices of the NCCA and the Cultural Center of the Philippines, or the CCP, the government bodies that administer the award. Arroyo also added 4 artists that had not undergone the entire screening process conducted by the aforementioned agencies: architect Francisco Bobby Maniosa, fashion designer Jose Pitoy Moreno, thespian Cecil Guidote Alvarez, and comic book writer and film director Carlo J. Caparas. The latter 2 choices were particularly galling to many. Guidote Alvarez at that time was the executive director of the NCCA and thus was deemed disqualified by the very guidelines of the commission she helmed, while Caparas was tagged as undeserving. Certain members of the artistic community were so outraged that besides engaging in various protest actions, they filed a petition with the Supreme Court on the 19th of August, seeking a temporary restraining order against the conferment of the rank and title of national artist upon the choices of the president, as well as a writ of prohibition that would permanently prevent the artists in question from being recognized and from receiving any benefits. The petitioners accused Arroyo of grave abuse of discretion, stated that the controversial exercise of presidential prerogative irretrievably taints the Order of National Artists, and asked that the limits of the discretion given to the president be defined to guide future selections. Nearly 4 years later, the Supreme Court has yet to render a decision on the matter, but it is necessary to attempt a cartography of the situation drawn along lines less vapid and vacuous than what had been ventilated. Strong, if not hysterical, denunciations of politics on the one hand, and elitism on the other. That prominent members of the art world have sought to bring this conflict into the realm of law, where it can presumably be settled in a final, unproblematic manner, the Supreme Court being the court of last resort after all, betrays the extent of the investment that artists have made in the power of the law to constrain and arrange their affairs, an investment that deserves urgent and diligent attention and critique. Contrary to statements that have been made deploring the politicization of the ONA, the honor, with or without the participation or interference, if one prefers, of the president is always already political, woven inextricably into and constitutive of the very fabric of power relations in and of the art world. Prodded to comment on the controversy in 2009, Nestor Hardin, at that time President and Artistic Director of the CCP Board of Trustees, stated that, "If you ask me personally, I think a new law has to be created, a law that will probably include measures that will safeguard the integrity of the award to avoid politicizing." It does not appear entirely unreasonable to posit that, without refusing the possibilities of difference and dissidence, this unquestioned, apparently thoroughly naturalized belief in the inevitability and efficacy of a legal solution is shared by a significant portion of the art community. It is worth noting that the ONA and the mechanisms by which it is granted are matters enshrined in law. The award was first established on the 27th of April 1972 by way of Proclamation Number 1001 issued by President Ferdinand E. Marcos shortly after the death of painter Fernando C. Amorsolo, and several other statutes or issuances with the force of law pertaining directly or obliquely to the award were promulgated in the years and administrations that followed. Although sociologist Randy David had a different art-related controversy in mind, his remarks are nevertheless pertinent in fleshing out the predicament that relegating the ONA issue to the judicial system creates. He says that art performs its social function best when it can create and sustain itself guided solely by its own unique code, which suggests a duty to preserve and fortify whatever autonomy it enjoys in society. An autonomy that, particularly in the Philippines, where art is still regarded as marginal to human communication, is extremely vulnerable to interference from other social spheres and cannot be secured by free riding on the legal system, however good it may be to invoke the protection of the Constitution for freedom of expression. What would seem to be called for then is a keen examination of the deeply fraught relationship between art and law. According to legal and aesthetic theorist Costas Dosinas, the law has creative prerogatives that can be traced back to medieval political and legal thought, which attribute to the Pope as the head of the Catholic Church the power of creatio ex nihilo, of making something out of nothing, a power that was exercised almost exclusively over legal matters, such that the Pope could create new law, provided this was not contrary to faith or natural law, and could waive the strict application of the law, thereby reversing the relationships between justice and injustice, and a power that was in time claimed and transferred to the emperor and then to princes, who, like the Pope, imitated nature by applying its laws while being able to create entirely new ones in response to changing circumstances, giving rise to world-making fictions like the institution of adoption, in which those unrelated by blood could mimic the natural function of the family, or the formation of the corporation as a juridical person, endowing it with rights, responsibilities, and obligations similar to that of a living human being. Duzina says that the operation of a series of equivalencies through the centuries, as when, for instance, the Italian Petrarch was compared to an ex officio emperor upon his being crowned poet laureate in 1341, ensured that by the Renaissance the power of creatio ex nihilo, which derived from God, had passed from the Pope to the legislator and the jurist, to the poet, and eventually to the artist at large, establishing an analog between law and art that would persist until the progressive professionalization and positivization of law gradually stripped the discipline of its spiritual claims and emotional investments, removed its study and scholarship from the humanities, and brought about its separation from art. Duzinas argues that even though art and the subjective responses that it evokes are held to be diametrically opposed to law and its reasoned, objective resolution of factual and doctrinal questions, the process of legal judgment reintroduces into the domain of law the very elements that law needs to keep away, such as sensory experience, fantasy, and memory. Similarly germane here is how sociologist Pierre Bourdieu has applied his notions of habitus and field in analyzing the legal realm. Like any other social field, the juridical field is a relatively autonomous, self-sustaining, self-perpetuating sphere of belief that is organized around a set of internal rules and assumptions, and within which agents at varying levels of technical competence compete against each other for resources. What is specifically at stake in the skirmishes between and among legal professionals is the right to determine the law, a confrontation that consists essentially in the socially recognized capacity to interpret a corpus of texts sanctifying a correct or legitimized version of the social world, and that contributes to the establishment of a social division between lay people and professionals by fostering a continual process of rationalization, which in turn increases the separation between judgments based upon the law and naive or vulgar ideas of justice, a separation that results in the system of juridical norms taking the appearance of total independence of the power relations that such a system sustains and legitimizes, both for those who impose these norms and for those upon whom the same are imposed. Bourdieu takes the trial, which is a confrontation between individual viewpoints resolved by the judgment of an authority with socially granted power, as paradigmatic of the symbolic struggle inherent in the larger social world for a monopoly of the power to impose a universally recognized principle of setting rules, fixing boundaries, or determining rightness in a legitimized manner. What judicial power does in this struggle, through judgments that are accompanied by penalties, which can include acts of physical constraint such as execution, imprisonment, or seizure of property, is to demonstrate the special point of view, transcending individual perspectives, the sovereign vision of the state which alone holds the monopoly of legitimized symbolic violence. Such judgments being representative of the quintessential form of authorized public official speech, which is spoken in the name of and to everyone, and possessing the magical power to make themselves universally recognized, thereby creating a situation in which no one can refuse or ignore the vision that they impose. In view of the foregoing, the enterprise of conferring awards, which is to say the enterprise of manufacturing and not merely acknowledging achievement, must always be understood as perilous and potentially debilitating, not least because prize giving is a typical instance of the games that individual and institutional agents play in advancing and reinforcing their claims to authority and legitimacy within the field of cultural production. The inevitable, if often disavowed, counterpart of making distinctions in order to advocate a certain aesthetic, to endorse specific practices, or, in some cases, draw evaluative attention to what seems to have been little noted or acted upon. That the ritual of hailing accomplishments in a given arena is usually a public mediagenic one, and as a result rather prone to spectacularization, as an ecstatic, even sublime event that somehow transcends or escapes the complex of social, political, and economic configurations making up the very ground of its possibility, can only compound the difficulty. Taken in from a broader perspective, awards, the rites that are designed around their delivery, the praise, respect, and camaraderie that they elicit, and the nearly obligatory eruptions of dissensus that they foment, are intricately bound up with the construction of collective memory, of determining what will be remembered, how such will be remembered, and who will do the remembering. An ever onerous and uncertain process, as exemplified by the fated figures of the past, who have since been relegated to the footnotes, if that, of the present. Therefore, I, who would function as a student of art history, is always already caught in these prize fights. Indeed, everyone, from the hardiest supporters to the bitterest detractors, is a complicitous participant. There is no margin of pure space into which one can retreat, no Archimedean vantage from which one can lever the art world up for disinterested scrutiny. As the performance artist Andrea Fraser has put it, we, the members of the art world, are all trapped in our field as we ourselves constitute that field, because the institutions of art, understood broadly as organized sites for the presentation of art, are inside of us, and we can't get outside ourselves. What matters then is not so much the fact of my complicity as the forms and degrees that I permit this complicity to take, the ways with which I deal with the implications of my inextricable involvement over the course of formulating styles of play, tactics of congenial and critical engagement, and strategies for imagining and instituting a different order. At their best, awards, as instruments and signals of value, represent fervent investments in the hope for the transformation of society, but these investments will only pay off if a vigilant guard is mounted against the witless, unrigorous purveyance and conveyance of benediction.